Madam Secretary, next agenda item, please.
The next item on the agenda is the consideration of the placement of Leonard Morgan Hairston to the list of excluded persons, case 22-01.
Right, this is the time and place set for the hearing to consider the exclusion of Leonard Morgan Hairston from licensed gaming establishments in the state of Nevada, case number 2201. The Nevada Gaming Control Board has nominated Mr. Hairston to the list of excluded persons based on the criteria set forth in NRS 463.151 subsection 2 and NRS 463.151 subsection 3A and D, and pursuant to Nevada Gaming Commission Regulation 28. This hearing will be conducted in accordance with the Nevada Gaming Commission Regulation 7.150 through 7.180. The commission is in receipt of the board's order of nomination. The bill of particulars and the notice of candidacy issued to Mr. Hairston and Mr. Hairston's request for a hearing on this matter. So Mr. Hairston here. Okay, you need to step forward, or you can have a seat right there in the front row. So that you know, this is going to work a little bit like a trial, if you will, a mini trial. All right, the board is going to make opening remarks. You have two options when he's done. You can make opening remarks, or you can wait until you present your own case. Okay, after that, the board will make a presentation. They've given us an exhibit list and a packet of exhibits. You have this, correct? Okay. And so after they present their case, if you have any questions, you are free to make those questions, since you don't have a lawyer representing you today, correct? Okay. So do you intend to use these records? You don't have any live testimony, correct? Or do you?
Chair, I do have one witness, yes.
Okay, that's fine. So they're going to swear in a witness, or we're going to swear in their witness. That witness will testify. They'll move to admit these exhibits. If you have some objection to them based upon the rules, or a basis to question their reliability, you can let me know. Then you will have the opportunity to ask any questions of the witness. Basically, the decision maker about what's appropriate going forward in this hearing and what's not is me. And so you'll direct your objections and kind of questions to me about procedure, but the substance of this case is being decided by the commission. So after they rest their case, you'll have an opportunity to testify. If you do so, it's under oath, subject to the penalties of perjury. If you have any exhibits, you have the opportunity to offer them at this time, any documentation or anything like that, when your turn comes. And then there will be an opportunity at the end of the evidence to present almost like a closing argument, closing statements, making your position and all the reasons for it known to us after the board does. Do you have any questions before we start? Okay. You ready?
I am. Good afternoon, Chair Tagliati, members of the commission, Madam Secretary, members of the board. For the record, I'm John McKellar with the Attorney General's office. Before you today is a hearing requested by Leonard Morgan Hairston for your determination as to whether Mr. Hairston should be added to Nevada's list of excluded persons. Before I start my opening statement, I have prepared exhibits 1 through 17 for the commission with regard to this matter. I provided all of these exhibits to Mr. Hairston on November 7th, so he should have had time to review them. If he is willing to agree to their admission, I would like to offer them for admission at this time.
Mr. Hairston, you told me that you had an opportunity to review the packet of exhibits 1 through 17. Can you speak into the microphone? Thank you.
Yes,
Did you
ma'am.
review them?
Yes, ma'am.
And what, if any, objection do you have to any of these exhibits?
I object for lack of jurisdiction.
Okay. Is that it?
Yes, ma'am.
Okay. By the way, as far as your objection goes, do you have any statute case, Nevada Supreme Court case, federal court case, that you can cite to support the objection based on your jurisdiction?
Yes, ma'am.
What's that?
Okay, it's right here. Okay, good morning. This is candidate Leonard Hairston. Okay, I'm objecting to the jurisdiction because jurisdiction is required in a case upon the filing of the complaint. That would be the notice of exclusion and the notice of bill of particulars. The Gaming Control Board failed to file the notice of exclusion, and they neglected to file the bill of particulars required by it's right here. Regulations 28 050 number 6, and in violation of this one right here. This one. Okay, by review of the exhibit list.
Yeah, we have that.
Okay, yeah. Okay, copy of notice of commission of counsel listed filed, and which I have, which was served to me in violation of due process. These bill of particulars was not filed properly and was served to me by these gaming control boards. They improperly served this, where these notice of candidacies are defective because it's not filed according to the proper filing, file stamp, time, date. And so all proceedings conducted for these don't require jurisdiction, and all orders and proceedings will be void and nullity. But I would allow the state to file these properly, to conduct these proceedings.
So what I think you're saying, if I'm not mistaken, is that exhibits 1 and 3, which are a copy of notice to commission of candidacy for
Uh-huh.
list, excuse me, you gotta let me finish talking, okay? Because we have a transcript and we have electronic transmission. And so when you're done, I speak. When I'm done, you speak. Can't talk over each other, just like court.
Okay.
'Cause we actually, you can't see her, but we have a court reporter who's transcribing this. And so it's important that we not
Yes, ma'am.
talk over each other, okay? So what I'm hearing you say is that the copy of the notice to commission of candidacy for list of excluded persons wasn't filed? Is that
Yes,
what you're
ma'am.
saying? Okay. And that the copy of the bill of particulars wasn't filed?
Yes, ma'am.
And was there something else you were saying wasn't filed?
Oh, that's it.
And then what I'm hearing you say after that is because they weren't filed, because what was served on you wasn't previously filed, you believe that there is no jurisdiction before the commission.
Yes,
Is that an accurate statement of what you're saying?
Yes, ma'am.
Okay, one moment, please. Your response?
Thank you, Chair. What we served on him were the pre-filed copies. I would ask you to take judicial notice of the fact that all of those things were in fact filed, and you can confirm with Madam Secretary that they were. So I don't believe that would be an issue at all.
So, so regulation 28 specifically indicates that he needs to be served the filed copies or be served generally before they're,
I don't have it in front of me, but,
let me ask,
um,
do we have the regulation? Okay. If I had internet, I could pull it up myself.
I think all that is required to be served on him is the notice of candidacy. Just going off memory, the bill of particulars is required to be filed if he so requests it. He never did request it. We gave it to him anyway, and we also filed that as well.
Thank you. One moment, please.
That is correct, Chair. Regulation 28060, subsection 6. I'm sorry, subsection 5, Chair.
Okay, so that relates specifically to, so 28060 says that after a candidate has requested a hearing before the commission, the candidate shall be entitled to receive upon request a bill of particulars specifying the grounds upon which a determination of exclusion was made. Such bill of particulars shall be furnished to the candidate at least 20 days prior to the hearing before the commission. It doesn't reference anything about it being filed or not filed that I can see, but about the notice of candidacy, as far as the regulation there, does it reference that it has to be a filed copy? I'm not seeing it. One moment, please.
Chair,
Excuse me. 28060, notice of candidacy. After the board has determined an individual should be placed upon the list, notice of such determination shall be given to said person by personal service, certified mail to the address of such person last known to the board, or publication once a day for 7 consecutive days, etc. All reasonable efforts shall be made to give such candidate actual notice of the proceedings, but the methods of notice are cumulative and may be utilized with or after independently of the above stated or other methods of a notice. Okay. Do you have anything else on that?
Yes, ma'am, Your Honor. Like I say, a review of the record shows that, the exhibit shows that I was given a file copy. I was not given a file copy. In order for the commission to conduct lawful proceedings, these documents has to be filed, just like in criminal cases. When the courts issue you an unfiled criminal complaint, the court does not acquire jurisdiction until a complaint is actually filed and served to you, not a copy of the unfiled complaint. So in the same proceedings, the judicial review of these cases would reflect that there's no authority to this.
What cases are you talking
I'm
about?
just saying, like the proceedings right now.
Okay, that's not a case. A case is something that's written by
Yeah,
the Nevada
okay, yeah,
Supreme
yeah,
Court.
I know, I'm
Okay,
sorry.
now let me finish my sentence and stop talking over me. It's going to be a really long day.
Okay.
Okay? A case, when you use words and you're going to choose to represent yourself, which is fine, but I need you to, to be able to have your best opportunity to make your argument, I have to understand it.
Okay,
Okay, so when you say case, you are referring to this case.
Okay.
You don't have any Supreme Court cases or any district court persuasive authority that you can cite to me, correct? That's not what you're talking about. You're talking about this case.
yes, ma'am.
Okay, just want to make sure. Go ahead.
Okay, but what I'm trying to say is though, an inspection of the exhibit list will show that I was served a filed copy.
I got that part.
Okay.
Do
And
you have
what-
anything to add to the argument?
Yes, ma'am, I'm just saying, without having a filed copy, they don't have no authority to present no cases or admit no
I
evidence.
understand that. Do you have anything to add?
No, no, ma'am.
Here's the thing. I spent 27 years listening for a living.
Mhm.
So when I ask you for any rebuttal, you don't have to repeat things 5
Okay.
times, okay? I hear you, I understand the argument, okay?
Thank you.
What I mean by that is that I spent a very long time as a member of the Nevada judiciary. So I am very familiar with the arguments you're making. The difference is here, there's different evidentiary standards, different procedural rules, and because the whole public policy driving the regulations is to give you notice and an opportunity to be heard, to give you fair opportunity to understand what's being alleged and why this is being requested by them. It is not going to be a situation where it's the equivalent of you being charged with a felony and you get a filed copy of a complaint.
Mhm.
So I appreciate your objection. I note it. And yeah. Yeah, but what does that have to do with when it's filed? I know, that's not the issue. He's saying that the fact that it doesn't have a file stamped copy like a court document. No, yeah. Okay, so how does that help me? Was he not served? Timely, is that what you're saying? Okay, so when was service in this case?
Your Honor, the exhibits were served November 7th, but service was actually, if you look at the last page of Exhibit 1, which I understand is not yet admitted as evidence, it was October 12th.
I'm sorry, could you say that again?
October 12th is when the notice of candidacy for the list of excluded persons as required by statute and regulation and the order of nomination to the list of excluded persons was served, and we did this by personal service on October 12th.
Okay. So, so as far as the 20 days service, I've kind of got questions being asked of me, and I want to make sure those things are covered for the record. The argument that's being made before me now is one that what Mr. Hairston is saying is because it doesn't say file stamped on it and it wasn't served to him that way, that we don't have jurisdiction. That's what he's saying. And I just want to make sure, as a separate point of order, that we have proper service in a time related to time, just to make sure the commission is satisfied with that record.
Okay, so
That's what you want, right?
we did serve Mr. Hairston on October 12th by personal service of the notice of candidacy and the order of nomination. And those are the only two things we are required to serve on him. The exhibit packet we served as a matter of courtesy to try and expedite this matter before, so he would have had time to review all those materials. But the only two things that were required to be served on him, we personally served on him. And those were not filed with the commission at the time because they were board actions.
Okay, so the bill of particulars was served 20 days before this hearing? Is that what you're
The bill
saying?
of particulars he never requested. It's only a 20-day requirement upon request. And we served those on him as soon as he made his request for hearing. And we served those on him as a matter of courtesy because he never did request the bill of particulars. But no, they were not done 20 days prior to this hearing.
Okay, so before we go any further with the objection of Mr. Hairston, does anyone else have any questions so that I don't, it's one of those awkward things where I'm supposed to make the determination, but it all kind of, it's substantive, it's procedural, they cross. So I'll do my procedural job, but I want to make sure that the substantive questions are answered about service and anything else that you have. I don't want to exclude you from that. Okay, go ahead.
I don't see anything in the regulation that requires a filed document as it relates to service. And I'm not sure who to pose this question to. Do I pose it to our counsel?
No, you are correct, Commissioner. There is nothing in the regulation that requires a filed copy to be served, just that it is actually served.
If there is on the exhibit list a document that says it was filed, does that somehow undermine that exhibit list?
And if I may, it doesn't say that it was filed, it just indicates the filing date.
Maybe it depends on how you read the comma. But you're sort of the prosecutor in this one. I'm asking my counsel.
If something is filed, Commissioner, it will just have a file stamped. That's just indicating when the commissioner or the executive secretary actually received the document. So the fact that he was served filed or not filed copy, that makes no difference in this case, as long as he has received an actual copy of the document.
Thank you. That's what I needed to hear.
Well, and I think a significant point here is that the purpose of filing it, unlike the criminal justice system, the purpose of filing it here is to give the public the notice, right, of what is going before the commission, for the public to know what's the actions being considered and undertaken, versus you having personal service of documents, placing you on notice and giving you an opportunity to be heard for these proceedings. So while I appreciate your objection, I understand your objection. Your objection's going to be overruled and we're going to go forward today. The good news is you've documented it in the event you wish to seek a judicial challenge later.
Thank you. Can I submit this as evidence?
Not right now, because that's not evidence, but you can do it if you want to do it in your case. When we talked about, remember, they go first, they put their case on, then you go after him and you put your case on. At that time, if you have any exhibits, then you will admit them or seek to have them admitted. Okay?
So let the record reflect, we're gonna waive the jurisdiction.
No, let the record reflect, I overruled your objection to
Oh.
jurisdiction and we're going forward.
Okay.
Okay, so have a seat.
Just
Okay, so
to,
your motion to admit the exhibits, for lack of a better term, is a motion. You move to admit them is granted.
and Chair, can I ask that exhibits 16 and 17 be admitted as confidential exhibits?
Yes, the record shall reflect that the request is made both on the exhibit list and contained in this exhibit 16 is an affidavit and a photograph and certified copies of photographs, fingerprints, and commitment records from the state prison are in 17.
All right. Thank you. Mr. Hairston is before you today for a decision on whether to place him on Nevada's list of excluded persons because he has been convicted of 3 felonies in Nevada and 5 crimes of moral turpitude, inclusive of the 3 felonies, all of which were gaming related based on gaming chip theft from licensees or patrons and counterfeiting of gaming chips. Additionally, Mr. Hairston has been ordered excluded from establishments which conduct gaming by the written order of a governmental agency by 2 courts. Pursuant to Nevada Revised Statute 463.151, a person may be placed on the list of excluded persons if the Board and Nevada Gaming Commission determine that the presence of the person in a Nevada gaming establishment poses a threat to the interests of Nevada or licensed gaming, or both. NRS 463.151 lists 7 factors for the Commission to consider in making its determination of whether to place a person on the list of excluded persons. 1. Prior felony convictions. 2. Crimes of moral turpitude. 3. Violations of the gaming laws of any state. 4. Failure to disclose a licensable gaming interest in Nevada. 5. Willful evasion of Nevada gaming fees or taxes. 6, notorious or unsavory reputation which would adversely affect public confidence and trust that the gaming industry is free from criminal or corruptive elements. And 7, a written order of a governmental agency which excludes or ejects a person from establishments with gaming. Nevada Gaming Commission Regulation 28.010 sets out that a finding of any one of these factors is sufficient to include a person on the list of excluded persons. Mr. Hairston satisfies 3 of the factors. 1, Mr. Hairston has prior felony convictions. 2, Mr. Hairston has been convicted of crimes of moral turpitude. And 3, Mr. Hairston has been excluded from establishments which conduct gaming by the written order of a governmental agency. 1, Mr. Hairston has been convicted of felonies in Nevada. On August 12, 2015, Mr. Hairston was convicted of attempted theft. On January 18, 2005, Mr. Hairston was convicted of attempted theft. On September 27, 2002, Mr. Hairston was convicted of grand larceny. 2, Mr. Hairston has been convicted of crimes of moral turpitude. A crime of moral turpitude is a crime that is contrary to the accepted rules of morality and the duties owed between persons or to society in general. In Nevada, a crime of moral turpitude includes crimes that constitute intentional wrongs with unlawful or improper intent. Both theft and cheating are crimes of moral turpitude. Mr. Hairston's felony convictions qualify as crimes of moral turpitude. Additionally, on February 14th, 2020, Mr. Hairston was convicted of conspiracy to commit a crime. This conviction was based on Mr. Hairston's attempt to manufacture a cheating device in the form of counterfeit gaming chips. On June 27th, 2008, Mr. Hairston was convicted of conspiracy to commit theft. And 3, Mr. Hairston has been excluded from establishments which conduct gaming by the written order of a governmental agency. On August 12th, 2015, a Nevada judge ordered as a probation condition of Mr. Hairston, quote, "Do not enter any gaming establishment, including bars, unless employed," unquote. On September 27th, 2002, a Nevada judge ordered as a probation condition for Mr. Hairston, quote, "Defendant not to gamble or enter into a gaming establishment during the term of probation." While the evidence will show that Mr. Hairston satisfies 3 of the factors the Commission may consider in placing a person on the list of excluded persons, I am only required to show that Mr. Hairston satisfies 1 of the factors. As I stated earlier, Nevada Gaming Commission Regulation 28.010 sets out that a finding of any one of the 3 factors I've just discussed is sufficient to include a person on the list of excluded persons. Further evidence that Mr. Hairston poses a threat to the interests of this state and/or licensed gaming is demonstrated by the fact that Mr. Hairston seems to be incapable of staying out of trouble in Nevada casinos. This is clearly demonstrated by the fact that Mr. Hairston has been arrested by Gaming Control Board agents, not other law enforcement agencies, approximately 34 times between 1990 and 2021, based on theft of casino gaming chips from licensees or patrons or counterfeit casino gaming chip production. Any one of the 3 criteria I present to you today is sufficient under 463.151 to place Mr. Hairston on the list of excluded persons. Thus, at the conclusion of this hearing, I request the Commission act today to place Mr. Hairston on Nevada's list of excluded persons. And thank you. And if Mr. Hairston doesn't have an opening statement, I will call my first witness.
Mr. Hairston, you have 2 options. You can make your opening statement now, or you can make your opening statement when you start your case,
Okay, I'll do it. When I start my case.
meaning reserve
Yes, ma'am.
your opening statement till your case.
Okay.
Is that what you wish to do?
Yes, ma'am.
Okay. You gonna call your witness?
Thank you, Chair. The Gaming Control Board calls Gaming Control Board Enforcement Agent Edward Farrell.
Sir, if you could come to the witness chair there and raise your right hand to be sworn by Madam Secretary.
Do you affirm that the testimony you are about to give before this commission will be the truth, the whole truth, and nothing but the truth?
Would you please state your name?
Edward Joseph Farrell III,
And will you spell that for the record, please?
Edward EDWARD, Joseph JOSEPH, Farrell FARRELL.
And do you have a nickname?
Yes, Ted,
Okay. Who is your employer?
the Nevada Gaming Control Board.
And what is your present position?
I'm an enforcement agent in the Special Investigations and Intelligence Division,
And how long have you held this position?
approximately 7 3/4 of a year.
Okay, and is this your entire tenure with the Gaming Control Board?
That's correct.
What are some of your duties?
Criminal and regulatory investigations in the gaming industry, list of excluded person investigations, and part-time task force officer for Homeland Security investigations.
Are you familiar with Leonard Morgan Hairston?
I am.
And how is that?
By reviewing Nevada Gaming Control Board records, filing a criminal investigation in the past for Mr. Hairston, and conducting a list of excluded persons investigation.
And have you conducted any of the investigations into Mr. Hairston?
I have one.
And what one was that?
That was the conspiracy to commit a crime investigation in 2019, where he was manufacturing
Okay.
casino chip,
Oh,
counterfeit
and-
casino chips.
Did you also personally serve Mr. Hairston some documents in this matter before the commission today?
I did.
And which documents were those?
That is the board's notification of candidacy and the notice of excuse me, notice of candidacy and the board notification for the list of excluded persons.
Okay. And when did you serve those?
That would be October 12th of 2022
And where did you serve those?
at his residence.
Okay. Will you please turn to Exhibit 1? Would you identify this for the record, please?
That is the notice of candidacy, the list of excluded persons.
And are there attachments to this exhibit?
There are.
Do you identify these for the record as well?
Excuse me. That's the order of nomination, the list of excluded persons. Notice of candidacy for list of excluded persons and the affidavit of service.
And is the affidavit of service an affidavit reflecting your personal service of Mr. Hairston?
That's correct.
Okay. And was it of those aforementioned documents?
Yes, they
And this has already been admitted. Would you please identify exhibits 4, 5, and 6 for the record?
4, 5, and 6. 4 is a judgment of conviction or plea of guilty. Exhibit 5 is a amended judgment of conviction, plea of guilty, and number 6 is an indictment.
Who is the subject of these exhibits?
Leonard Morgan Hairston.
Do these exhibits reflect whether Mr. Hairston has been convicted of a felony?
They do.
And what felony?
Attempted theft.
When was Mr. Hairston convicted of the felony?
June 17th, 2015.
In what state was Mr. Hairston convicted of the felony?
Nevada.
Do you know what the basis of this felony was?
I do.
And how do you know that?
Review of Nevada Gaming Control Board records.
Okay, and what was the basis of this felony?
While at the Wynn, he attempted to steal casino chips from a patron.
Would you please turn to the last page of Exhibit 4? And this is the previously identified judgment of conviction, plea of guilty, correct?
Correct.
Are there special probation conditions on this page?
Yes, sir.
Would you please read special condition number 1 into the record?
Do not enter any gaming establishment, including bars, unless employed.
Would you please turn to page 3 of Exhibit 5? This is the previously identified amended judgment of conviction, plea of guilty, correct?
Correct.
Are there special probation conditions on this page?
Yes.
Would you please read special condition number 1 into the record?
Defendant may not enter any gambling establishment unless employed.
And these exhibits were already admitted. Would you please identify exhibits 7 and 8 for the record?
7 is a judgment of conviction, plea of guilty, and 8 is guilty plea agreement.
Okay. And what is the case number for those?
Not seeing it off in here.
It's on the top right. Just to the right of the,
Oh, okay. Excuse me. C204739.
okay. And who is the subject of these exhibits?
Leonard Morgan Hairston.
Do these exhibits reflect whether Mr. Hairston has been convicted of a felony?
They do.
What felony?
Attempted theft.
When was Mr. Hairston convicted of the felony?
December 16th, 2000,
And in what state?
Nevada.
And do you know what the basis of this felony was?
I do.
And how do you know?
Review of Nevada Game Control Board records.
Okay. What was the basis of this felony?
Mr. Hairston had attempted to redeem counterfeit palm chips at the Fremont Casino and the Fitzgerald's.
Okay. Do you know what agency made the arrest for this case?
I do.
And how do you know that?
Reviewing Nevada Nevada Control Board, Gaming Control Board records.
Okay. And what agency?
Nevada Gaming Control Board.
Okay. Do you know if the agent performed a search incident to the arrest?
I do.
And how do you know that?
By reviewing Nevada Gaming Control Board records.
Did the agent perform a search incident to the
The
arrest?
agent did.
Okay. Do you know what was found in the search incident to the arrest?
I do.
And how do you know that?
By reviewing Nevada Gaming Control Board records.
And what was found?
The components to make counterfeit chips and counterfeit chips themselves.
Would you please identify exhibits 9 and 10 for the record?
Number 9 is a judgment of conviction, plea of guilty, and 10 is a guilty plea agreement.
And what is the case number for those?
C185143.
Who is the subject of these exhibits?
Leonard M. Stone, aka Leonard M. Martin Stone, aka Leonard Morgan Stone.
Okay, and is this the person who is before the commission today?
It is.
And how do you know that Mr. Hairston is the subject of exhibit 9 when he is not named in the caption?
Because exhibit 10 has the same case and the same identification numbers for Mr. Hairston in scope.
Okay, when you say the same identification number, what sort of identification number are you referring to?
The social security number isn't.
Is it, would it be correct that it's a Nevada ID number?
That is a Nevada ID, yes.
And is that Nevada ID number listed in any criminal databases?
Yes,
And what databases is it listed in?
it's listed in scope.
Okay, and what is scope?
Scope is a database that not details but lists past criminal convictions and arrests.
Okay, and who's that database available to?
Law enforcement and prosecutors.
Okay. And going back a few questions, this ID number listed in the caption on this case, that is also in scope?
Yes, it is.
And who is the subject of that ID number in scope?
Mr. Hairston.
Okay. Do these exhibits reflect whether Mr. Hairston has been convicted of a felony?
I do.
And what felony is that?
Attempted larceny.
Okay. When was Mr. Hairston convicted of the felony?
September 17, 2002,
In what state was Mr. Hairston convicted?
Nevada.
Do you know what the basis of the felony was?
Yes, he had attempted to steal gaming chips from a patron, or from a patron at the Bellagio for $5,000 chips.
Okay. Would you turn to Exhibit 16 and read paragraphs 23 and 24 to yourself, please? Okay. Now, going back, you stated that it was a theft from patrons at the Bellagio. Do you have any clarifications?
Yes, I was mistaken. That's from a roulette bank,
Okay.
not a table game.
Would you please turn to the last page of Exhibit 9? This is the previously identified judgment of conviction, plea of guilty, correct?
That's correct.
Are there probation conditions on this page?
Yes, sir.
Would you please read special condition number 3 into the record?
Defendant not to gamble or enter into a gaming establishment during the term of probation.
Would you please identify exhibits 11, 12, and 13 for the record?
11 is a judgment of conviction, plea of guilty. 12 is an indictment, and 13 is an amended indictment.
Okay, and what is the case number for those exhibits?
C1934202441.
Who is the subject of these exhibits?
Leonard Morgan Hairston.
Do these exhibits reflect whether Mr. Hairston has been convicted of a crime?
They do.
And what crime?
Conspiracy to commit a crime.
When was Mr. Hairston convicted of this crime?
February 13th, 2020.
And in what state?
Nevada.
Do you know what the basis of the crime was?
I do.
And how do you know that?
Reviewing personal Nevada Gaming Control Board records, and I conducted this investigation myself.
Okay. And what was the basis of the crime?
Well, housed at the Casa Grande transitional facility, parole and probation officers searched Mr. Hairston's possessions, and there was components to make counterfeit casino chips.
Would you please identify exhibits 14 and 15 for the record?
14 is a judgment of conviction, plea of guilty, and 15 is a guilty plea agreement.
Who is the subject of these exhibits?
Leonard Hairston.
Do these exhibits reflect whether Mr. Hairston has been convicted of a crime?
They do.
What crime?
Conspiracy to commit theft.
When was Mr. Hairston convicted of this crime?
May 5th, 2008.
In what state was Mr. Hairston convicted of this crime?
Nevada.
Do you know what the basis of this crime was?
I do.
How do you know that?
Reviewing Nevada Gaming Control Board records.
Okay, and then let me back up. I don't think we read the case number into the record, so would you please do that?
C239587.
Okay. And what was the basis of the crime?
At Caesar's Palace, Mr. Hairston distracted a table games dealer while an associate stole gaming chips off a table bank.
Would you please identify exhibit 16 for the record?
That is my affidavit.
Okay. What does it contain?
It contains my research into Mr. Hairston in the Nevada Gaming Control Board database and records, and then synopsises of the crimes that we're speaking of today.
When did you sign it?
September 6th, 2022.
Is there an attachment to exhibit 16?
There is.
Who obtained the attachment?
I did.
How did you obtain the attachment?
I used a scope to attain it.
Okay. What is the attachment?
It's a picture of Mr. Hairston.
And how do you know it is a picture of Mr. Hairston?
Reviewing Nevada Game Control Board records, personal relations with Mr. Hairston, and the case that I brought forth against Mr. Hairston.
Is the Mr. Hairston, is this the Mr. Hairston, which is the subject of this hearing today?
It is.
How do you know?
Reviewing Nevada Game Control Board records, personal interaction, and the case which I investigated.
Do you know if Mr. Hairston has a history of interactions with the Nevada Gaming Control Board?
I do.
And how do you know that?
Reviewing Nevada Gaming Control Board records and scope.
As well as your personal
Well,
investigation. Does Mr. Hairston have such history?
he does.
What is this history comprised of?
Dozens of arrests in Nevada in the gaming industry. Dozens of arrests in Nevada for gaming crimes.
And when you say dozens, could you put a more precise number on that?
34 times.
Okay. How far back does this arrest history go?
1990.
Okay. And you said it was 34 times. Would you identify Exhibit 17 for the record, please?
There's an order for revocation of probation and second amended judgment of conviction, plea of guilty.
And if you turn to the last page of Exhibit 17, would it be fair in looking at that to characterize Exhibit 17 as excerpts from Mr. Hairston's prison record?
It would.
Who obtained this?
I did.
Is it certified?
It is.
What does Exhibit 17 contain?
Again, it's the order for revocation of probation and second amended judgment of conviction. He's got it's a picture of Mr. Hairston, identifying numbers, birth dates. There's a fingerprint record for Mr. Hairston.
Okay. Do you know if Mr. Hairston still resides in Nevada?
I do.
Does he? Or, sorry, let me back up. How do you know this?
I visited him at his residence when I served him the notice of candidacy and the board notification for list of excluded persons.
Okay, and I think that goes to my next question. And does he still reside in Nevada?
He does.
Okay. Is the Leonard Morgan Hairston that you investigated present today?
He is.
Would you please identify him?
Sitting in the first row with a green hooded sweatshirt.
Okay. How do you know that this is the person that was the subject of your investigation?
By reviewing the Nevada Game Control Board records and personal interaction with Mr.
Thank you.
I'm sorry, I thought it was up. Apologize. So after you moved to admit the exhibits, Mr. Hairston had his objection based on jurisdiction. That record's been made. But the record that I did not make is that even though the rules of evidence don't technically apply to these exhibits, evidence that's relevant, which this obviously is sufficient to support a finding and be considered by the commission if it is reliable. Based upon my review of these exhibits and having firsthand knowledge of what a judgment of conviction looks like, what a guilty plea agreement looks like, what scope records look like, what Nevada Department of Corrections records look like, these documents are obviously reliable. And that was also a consideration on my part when I admitted them or had them admitted for the consideration of the commission, and I neglected to mention that. So I'm doing so at this time. Mr. Hairston, now is your opportunity to have to ask the questions, any questions of the witness that you may have that are relevant to these proceedings?
Yes, ma'am. Mr. Farrell, good morning.
Morning. Afternoon.
You indicated that, the Game and Control Board arrested me 34 times, right?
Yes,
Theft crimes, right?
excuse me.
Theft crimes? But theft crime?
Mr. Harrison, yeah,
Or
can you pull the
Crimes
mic?
related to theft,
Yes, ma'am. Okay,
that was included.
okay. Okay, what I have here is legal documents, the Enforcement Division, Game Control Board. The Enforcement Division of the board investigate cheating. Its members are law enforcement officers. And- Mhm. Yes, ma'am. Mhm, mhm. No. Okay. Okay. Mhm. Okay, thank you. Okay, okay, again, you said you made arrests 34 times against me,
I
right?
did not personally.
Well, okay, okay. I want you to know that pursuant to NRS 465-101, detention and questioning of persons suspected of violating chapters limiting liability posted of notice. Each of those arrests that are committed in the game establishment was theft crimes. So the Game Control Board, all the arrests that they made was unlawful arrest because under NRS 465.
I'm going to object, Your Honor.
Okay. 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 Yes, ma'am. Okay. Mr. Farrell, did you serve me an unfiled copy of the bill of particulars?
I did not.
Okay. Mr. Farrell, did the Game Control Board arrest me 34 times for theft crimes?
Not necessarily theft crimes, but crimes involving the gaming industry.
Okay, but these crimes wasn't in pursuant to NRS 465.
In addition to 465, there were some other ones as well.
Yeah, but there was none under 465. I was never arrested under NRS 465. I was never arrested for gaming crimes. I was always arrested for a theft crime. So the crimes that I was arrested for was unlawful because it wasn't in pursuant to NRS 465. And the convictions was void convictions because when I appealed the convictions to the Nevada Supreme Court, the Supreme Court dismissed all the cases. Mhm. Okay. 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 Thank you. Okay. Thank you. Thank you. Thank you. Yes, ma'am. Mr. Farrell, was those crimes I was arrested for, was they gaming crimes or property crimes?
Both.
No.
Chair Tagliati, please turn on your mic.
I'm sorry. So if you have a crime that you believe is a gaming crime,
Mhm.
excuse me, a theft crime and not a gaming crime, then ask him that specifically related to your records.
Okay.
If you don't, this is going to be, again,
Yes,
I
ma'am.
can't allow it because
Okay.
you can't tell him
Okay.
what you are arguing.
Yes, ma'am. Gotcha.
Okay.
Okay. Okay, Mr. Farrell, those crimes that I was arrested for, they was all theft crimes. Pursuant to NRS 265, attempt theft, grand larceny, theft, burglaries. They was under NRS 265, right?
Mr. Hairston, two things. One, you've been saying 465, now you're saying 265. Which one is it?
265.
Okay. Two, do you have one in particular that you would like to bring to his attention and ask him that?
Yes, ma'am. The 34 crimes that the Game Control Board arrested me for, they was all under 265, correct?
No.
Okay, all right. That's enough.
Okay?
Okay.
Do you have any rebuttal questions?
Just a few, Chair. Mr. Farrell, are you certified by the Peace Officer Standards and Training Commission?
I am.
Does that give you certain law enforcement authorities?
It does.
Are those limited strictly to Chapter 465 of the NRS?
It does not.
Okay. What other things can you arrest for beyond gaming crimes?
Any statutory crime
Okay.
in Nevada.
And generally speaking, if you know, are enforcement agents of the Gaming Control Board all post-certified?
They are.
And is it, I'm trying to remember a little bit about post-certification. Is it level 2 certified?
The requirement for hiring is level 2, but we're all level 1 or category 1 rather.
That's what it is, category 1, and that's higher than category 2.
Yes.
Okay. And then would you turn to Exhibit 12, please? Just by way of quick rebuttal, what chapters was the arrest made according to this document for case number C-342024-1?
Chapter 465. Or
And so specifically 465.085, 465.088, and then also chapter 193.330.
yes, sir.
Okay. That's all I have, Chair.
Mr. Hairston, do you have any additional questions? You have to base them upon the questions he just asked.
Okay. Okay, yes, Mr. Farrell. On June 27, 2008, Leonard Hairston was convicted of Nevada of conspiracy to commit theft in violation of NRS 199480. Correct?
Can you repeat that?
Okay. On about June 27, 2008, Leonard Morgan Hairston was convicted in Nevada of conspiracy to commit theft in violation of NRS 199480. Correct?
Which case would you be looking at?
Okay, we're looking at, what case is this? This is count 2, number 6E. And let's see what we got here.
Are you looking at an exhibit by any chance?
Just look at this right here.
Oh, I see. Okay.
Yeah. But yeah, Mr. Farrell, well, all these arrests right here is under NRS 193, NRS 205, NRS 199, and they're not in violation of NRS 465. So that didn't authorize the Gaming Control Board to arrest me for those crimes. So all those crimes that I was arrested for was unlawful arrests by the Nevada Gaming Control Board.
Is that a question?
Yes.
Correct, is what he's meant to add at the end.
That's incorrect.
No. Okay. Well, like I say, pursuant to NRS 465-101, Mr. Farrell, Gaming Control Board agents was only allowed to make arrests for gaming crimes. So the crimes that I was arrested for wasn't a gaming crime. It was a property crime. Correct?
As the category 1 peace officer, I'm
Not
authorized to.
Not pursuant to statute, NRS 465-101. You violated the statute when you arrested me for property crimes.
Okay, so there was an objection made that was likely not caught by the court reporter because you're not at the microphone, and I'm the biggest perpetrator of such things. So I will make a record that the AG objects. I agree with him. This is argument. If you have specific questions of the witness about any exhibit or anything he testified to, or you want to have him comment on Nevada law or his post-certification and how he's trained, you can do that, but you have to ask questions. You can't argue with him and state that he did something illegal, because that's just
Okay.
an argument, and you're free to make that, but we're at the wrong time for that.
Okay.
So right now, not limiting your questions. Please continue if you have any more.
Okay. Mr. Farrell, are you authorized by NRS 465-101 to make an arrest for property crimes?
Yes.
Okay, I'm done, Your Honor.
Okay,
Okay.
thank you. Thank you very much for your testimony. You're excused.
So the court reporter can hear. The board rests, Your Honor.
Okay, so there being no other witnesses or evidence presented by the board at this time, Mr. Hairston, first of all, if you wish to testify before you make argument, I guess the first thing I need to know is, do you wish to make an opening statement before you start your case? So step forward to the microphone. Now, there's a difference between an opening statement and testifying. You're going to make an opening statement that you can include anything you'd like. Then you're going to make sworn statements, presumably, if you so choose, where you would be subject to cross-examination if you choose to make those statements to put evidence in the record. And then at the end, you'll have an opportunity to respond to factual and legal arguments made. So now is the time for the opening statement.
Again, Your Honor, I just want to make a statement that the court, right, the administrative hearing, the commission, they lack jurisdiction to proceed with these proceedings because the Gaming Control Board failed to file me a notice of exclusion, and they neglected and failed to file me a notice of bill of particulars.
You mean serve you with a filed copy?
Yes, ma'am.
Okay,
That's
when you
all
say
right.
file me, that
File-
sounds painful.
Miss, what's that?
I said, you said file me, and I
Oh,
said,
okay.
that sounds like it hurts.
Okay, yeah.
Okay, so
Okay.
I know what you're trying to say, and I'm just not giving you a hard time. I'm just want to make the record clear for
Yes,
you,
ma'am.
okay?
And like I say, in jurisdiction is required in this case by filing of the bill of particulars and the exclusion of persons. And such, and without filing these documents, the proceedings would be null and void. 'Cause they wouldn't have no effect because there was nothing filed to serve me, so that was a defect in the notice of process of service.
You made a record of that.
Okay, that's all I
Now,
have to
now
say.
is your opportunity to tell us what other evidence or arguments you intend to, since we've
Oh, okay.
addressed that one.
Well, like I say, the Gaming Control Board, they violated my constitutional rights because when they arrested me, they arrested me in the violation of NRS 465-101 because they arrested me for property crimes in NRS 265. And the law states the Gaming Control Board can only make arrests for gaming crimes. So when I was arrested, I did not commit a gaming crime. And so when you commit a gaming crime, the licensee is under the statute, they are required to call the Nevada Gaming Control Board to inform them that I committed a cheating crime, like chips and all that kind of stuff, but I never did that.
Okay, so I understand that's another legal argument that you've made. Do you have the intention to be placed under oath and testify about any of the evidence in the case, as far as, there's a difference between facts and legal arguments. You've made a lot of legal arguments today. Do you have any facts you wish to put forward for us, in which case you would need to? So for example, if you were going to say something about one of the offenses, it was this, it wasn't that kind of thing, where you're actually talking about facts, then you would be sworn.
Mhm.
And so do you have the desire to be sworn and present any evidence on your behalf related to facts?
No, ma'am, because like I say, without being served properly, the evidence is admissible now, so I don't have nothing to say.
Well, the good news is, since you made the objection already, and it's been documented in the record, you can still present facts without waiving your jurisdictional argument.
Mhm.
So if things don't go your way today and you choose to undertake judicial review, you've made that argument and you've protected the record and you've preserved the objection. So you can feel free to put forward any evidence that you choose, because here's the thing. If you lose, if you have all your eggs in that basket or all your marbles in that jar,
Mhm.
and you lose before the courts and they say Tagliati was right, Hairston was wrong, then you're done. And you don't have the opportunity to come back here and tell us facts if you have any that you want us to know. So because you've preserved the legal argument, it's not going anywhere. If things don't work out for you today, you can challenge what decision I made today on the jurisdictional argument, and we can, you can pursue that,
Mhm.
but you won't have a chance to come back if you lose and tell us any facts you want us to know. So you should do so if you want to. If there's facts that are relevant to this that you want to point out anywhere about any of these charges, cases, theft versus gaming, any of the facts, you should do so, because if you're not successful on that challenge, you won't get an opportunity to come back. And all of this is going to be considered by basically
Yes,
your
ma'am.
jury.
Right. Yeah.
So do you have any evidence or testimony you wish to present related to any facts that are underlying these exhibits or anything else in the case?
Yes, ma'am.
Okay.
Okay.
So what we're going to do then is I just need you to raise your right hand and be sworn.
Yeah.
Mm-hmm.
Do you affirm that the testimony you are about to give before this commission will be the truth, the whole truth, and nothing but the truth?
Okay. Could you say yes into the microphone?
Yes.
Okay. So if you want, go ahead and sit there so you have your papers and you're not rushed. When you're ready.
I'm ready.
Okay.
Okay. Yes, ma'am. In 2008, I was charged with possession of a cheating device and conspiracy to cheat at gambling. I took that case to trial and that case was dismissed for lack of evidence. I have the exhibit here.
Okay. Could somebody grab it for me? I'll take it. So, Mr. Hairston, do you want to admit this?
Yes, ma'am.
Okay, then give me a second. Hold on 1 second. Let me look it over first and then. So can you take a look at this? This basically is a register of action document related to C 243104 that shows that it was dismissed. Pursuant to an oral motion to dismiss. Can you look that over before? So he gets to be heard on whether he objects to its admission. If he doesn't object, it'll be admitted.
Chair, for the record, I would note that it is not a certified copy, but to me it appears to be a printout from the 8th Judicial District's website of the docket. for a specific case number that I did not rely on for this case. All that being said, I don't have any objection to it being admitted.
Okay, well, I find it's evidence that is reliable and the sort of evidence which responsible persons are accustomed to relying on in the conduct of serious affairs. And one thing I know is court records, and this looks accurate, so it's going to be admitted. Next, please continue.
Yeah, in 2009, I appealed my conviction from that of attempt theft to the Nevada Supreme Court, and the Supreme Court dismissed the appeal for lack of jurisdiction in the lower court, and dismissed the case for attempt theft and entered it in the minutes of the records. And so I was convicted, I was subjected to double jeopardy in that case because they never filed the charges in that case. And they,
Okay, why don't we hand that to?
oh yeah,
Let's just see how many we get. Okay, so we're gonna mark the first one, defendants A. This will be defendants B. It's an ODA, also known as an order dismissing appeal in Supreme Court case 54089. Attached to that is a clerk certificate from the 8th Judicial District, excuse me, the Supreme Court, entering judgment, and what appears to be the register of actions for Supreme Court, at least partially. And then, I'm not sure what this last page is, says sentencing.
yeah, they gave me 1 day of probation. And
Okay.
then after that, the Supreme Court had already closed the case for lack of jurisdiction, but the court took me to court and made me take a deal for 1 day probation. I was the first person in the state of Nevada to get 1 day probation.
Okay,
Case that got dismissed.
all right.
Chair, while those do appear to be documents on which you could rely, I think I will lodge an objection based on relevance at this point because it's not a case that I relied on to make my case. It's not anything I'm arguing for his inclusion on the list of excluded persons.
Look, the way I kind of see this is that, you know, I think the testimony, if it helps him to establish the argument that he's trying to make, it goes to weight, not admissibility. I think I get the gist of what he's trying to demonstrate. I just don't see any prejudice to you at this point, so I'm going to admit it. I'm going to have it admitted as B and let the commissioners determine what weight to give it, if any.
Thank you.
Yes, sir. Hold on, I'll put post-its.
In 2014, I have an appeal from a conviction of attempt theft, which the Supreme Court dismissed the appeal for lack of jurisdiction in the district court because they never filed the charges because I was subjected to double jeopardy. The Supreme Court issued a remitter in an order of dismissal, and the dismissal was entered in the court records and a conviction and a double jeopardy of a judgment of dismissal and a judgment of conviction was entered. So I was subjected to double jeopardy, and the Supreme Court dismissed the whole case.
Okay.
Commissioner, can I get a copy of those back?
Sure. It's gonna have to be after.
Okay.
Okay. I was gonna pass them down, like, down this way. We can mark them later, right? I put the Post-its on them. So you could look these over. Okay, as to defendants, as I say, defendant, respondents, proposed C, it appears to, I guess the question is, understanding that there's kind of a panoply of documents here, do you have reason to question the gist of what, that this, in his view, documents what he's saying about it being dismissed?
I would note for the record, Chair, that it was his appeal that was dismissed in that document, not the case against him that was dismissed. And I think it's important to note that for the record, because that appeal does concern one of the cases that I did present testimony and evidence on. And so the record, I don't have any objection to that furthering the record, but I think it needs to be properly characterized as the dismissal of the Supreme Court was of Mr. Hairston's appeal, not the case.
Okay, well, what I'm going to do is I'm going to admit, sorry, thank you, defendant C. There is a notation on page 2 of 11, which would be the 4th page of the document dated October 29th, 2014, that reads Nevada Supreme Court Clerk Certificate / Judgment dismissed, and remitter was issued. So I understand there were all kinds of things that happened after that, but once remitter, I mean, the notice of appeal and a motion to recall the remitter, then there's a whole plethora of things. I think my esteemed fellow commissioners can figure out this court record. So I'm going to go ahead and admit it and let everybody review it and let it speak for itself. Next.
I have one more. Okay, this was from 2019, and this is an order dismissing the appeal for lack of jurisdiction in the lower court for the charge of the Supreme Court filed this order of dismissal, and they issued a letter to the lower court with an order of dismissal, dismissing the whole case.
So this would be proposed defendants, respondents D. I'm just used to plaintiffs and defendants, so that's your law. That's a regular lawsuit. Just what this feels like.
Oh, Mr. Commissioner, and they have this one right here. This is why they dismissed it, for lack of jurisdiction in the lower court. Mhm.
Okay, could you grab that extra page, please, Mr. Psalms?
So they just dismissed the appeal for lack of jurisdiction in the lower courts.
When they're done looking at it, I'm gonna pass it down. I had Psalms on the brain. Sorry. I'm just hyper focused. Apologize. I know who you are. Apologize. Okay, I'm passing down defendants C so that you can look at that. That's C.
Oh, gotcha.
Okay. So just so that Mr. Hairston, because the commission is going to be deliberating and discussing presumably today before the conclusion of the meeting, I'm passing them around for them to review.
Yes, ma'am.
In the meantime, I'm going to ask what objection, if any, you have to defendant's proposed D, which for the record is 1, 2, 3, 4, 5, 6, 7, 8 pages long.
Thank you, Chair. No objection, and while understanding that the commission will read it and determine what weight and what it means for themselves, I would note for the record that it was Mr. Hairston's appeal that was dismissed, not the case.
Okay, so D will be admitted. And do you have a paper clip or something? There's one loose page on this. Thank you. So I'll pass it this way and then work it that way. One moment. Okay, please continue.
Yes, ma'am. Yes, ma'am. I contacted Nevada Supreme Court clerk, and she informed me that an order of dismissal dismisses the case. It's not going to show. It's not going to say that the case was dismissed. The order of dismissal dismisses the case, and when the clerk of the district court enters that into the minutes, it terminates the jurisdiction of the district court. And so what I was subjected to was a false imprisonment because they went ahead and convicted me after the case has been closed. And so the Supreme Court told me that the case was closed when that remittal was issued back to the lower court, and they ignored to execute the judgment of dismissal after it's been remitted back down to the lower court. So that's what happened on that. Then I want to go to NRS 465101. I want to admit it to evidence. So you can review that the detention in question of persons suspected of violating chapters, limitations, and liability. Okay. So like I say, all the arrests that the Gaming Control Board prompted towards me was in violation of NRS 465101. So, and like I say right here in the Prevention Enforcement Division, Gaming Control Board, the Enforcement Division of the Board investigates cheating. Its members are law enforcement officers and can make arrests for gaming crimes. So all the crimes that I was subjected to was property crimes in pursuant to NRS 265.
So what you have in your hand there is a copy of a statute, correct?
Yeah.
Okay, you don't have to admit that as evidence. You're just asking us to take notice
Okay.
of NRS 465.101. Is that correct?
Yes, ma'am.
Any other statutes you're asking us to take notice of as
Yes,
part of our?
NRS 265. Those are property crimes. So like I say, if the Gaming Control Board, if they was at a casino and someone was guilty of prostitution or stealing some liquor out the gift shop, they would be unauthorized to make those type of arrests because it's not cheating crimes. So the casinos would be liable if they called the Gaming Control Board for a theft crime. Because inside the casinos, they got a posted board to let you know that anybody who's violating the gaming laws, they're entitled to call the Gaming Control Board to come there and make the arrest. But in my situation, the arrest I did in the casinos was theft crimes, not gaming crimes. And so that subjected me to unlawful arrest. They didn't have authority pursuant to the NRS 465 to arrest me 34 times for gaming crimes, even though they were theft crimes.
Okay,
Okay, and then there's one more. I want to admit mode of acquiring jurisdiction.
I'm sorry, could you restate that, please? I can't hear you.
Again, yeah. I'm going to submit this into evidence. Mode of acquiring jurisdiction. Jurisdiction is acquired in a criminal case, but this is not a criminal case, upon the filing of a complaint. So a complaint in this case is this right here. What they say, a complaint shall mean the notice of exclusion and the bill of particulars. That would be the complaint in this case. Here. So like I say, the Gaming Control Board, they never served me with a file copy. And so with them not serving me with the file copy, deprived the Judicial Commission and the Commission of authority to do proceedings towards this case, this hearing right here. But like I say,
Mr. Harrison,
Hmm?
I have respect for the fact that you came here with arguments to make. You brought paperwork to support the arguments, and I don't have any trouble with anything you've done here today. The only issue is, repeating things over and over. I've got you. I understand your argument. If anybody on this commission agrees with that argument, I'm sure that will weigh into the decision they make in this case. But I have made a decision and you need to move on from that. Okay? You made a record 5, 6, 7 times. You're good, I promise, as far as making that record and having someone review it if you needed to in the 8th Judicial District. But for today, I need you to move on from that argument unless you have something else to add. Just saying it over and over and over again doesn't make it any more compelling. You know, I get it. You respect, you know, you believe I'm wrong. Okay, got to move on. So, do you have anything else related to the evidence, the convictions? We have the exhibits, they've been admitted. You're going to get to make argument again. And so, I'm done with Exhibit D because she hasn't seen it yet.
Sorry.
Do you have anything else as far as testimony or exhibits?
No.
Okay. Now is the opportunity for counsel to cross-examine you and ask any questions that you got to stay where you are because you're still under oath. And his questions, I will limit them to what you've testified here to today, if it's relevant to that.
Chair, I will do you one better and not make this hearing any longer and not have any questions for Mr. Hairston.
Okay, there have been no questions. And so at this time, you're welcome to take your seat back over there. Listen to I believe that's going to conclude the evidence today based upon what Mr. Hairston has said. And I assume you have nothing in rebuttal?
No, Chair, I do not.
Okay, so. Yeah, I just asked him if he has anything. So you have no other additional witnesses or evidence to present, correct? All right, so you're resting now. They've rested. Now is the time for the argument to close the presentation, okay? So you will have an opportunity to respond to what he argues and make any additional arguments you want to make for yourself.
Thank you, Chair Tagliati. Leonard Morgan Hairston belongs on Nevada's list of excluded persons. As I went over in my opening argument, there are 7 factors the Commission may consider in making the determination of whether to place a person on the list of excluded persons. I only needed to prove that Mr. Hairston satisfies one of those 7 factors. I proved that he satisfied 3. But before I get into that, I just want to note for the record my arguments regarding Mr. Hairston's arguments. He claims that there's a lack of jurisdiction because the board failed to serve a filed copy of the bill in particulars and order of exclusion, and that everything's null and void. And I understand that the chair already ruled against that. But I'd like to highlight that all that's required to initiate these proceedings before the Commission are service of the notice of candidacy, which is a Gaming Control Board document, and the order of nomination, also a Gaming Control Board document. And Exhibit 1 of the admitted exhibits includes both of these. Also, 463.151 is based on felony convictions, convictions of crimes of moral turpitude, and orders of exclusions from gaming establishments. I showed all 3 of these things today. These convictions are not limited to gaming crimes, whether it's felonies or crimes of moral turpitude. With regard to the unlawful arrest arguments, Mr. Hairston should have made those during the criminal proceedings. This is not the proper forum for those. All that matters is that I showed he was convicted of the crimes of moral turpitude and the felonies. I would note, even though it's not necessary to do so, that Gaming Control Board agents are in fact authorized to make arrests for non-gaming crimes. They're Category 1 peace officers under the Peace Officer Standards and Training Commission. Mr. Farrell testified to that. And I would also add to that, Chapter 289.360 specifically authorizes Gaming Control Board agents to make arrests outside of gaming crimes. So, Mr. Hairston has been convicted of 3 felonies. There's one factor. I only need one, but there's one for you. Mr. Hairston has been convicted of 5 crimes of moral turpitude. We're up to 2 when I only need one. And finally, 3, Mr. Hairston has been excluded from establishments which conduct gaming by the written order of a governmental agency. I also showed that. So of the required 1, I have proved 3. Mr. Hairston argues the Supreme Court dismissed some of these cases against him. However, and my admittedly quick read, since I had not seen those exhibits prior to today, those dismissals were not of the underlying criminal cases. They were of Mr. Hairston's appeals of those convictions, and his appeals were dismissed. In addition to those 3 factors you're allowed to consider for the list of excluded persons, I also add to it that Mr. Hairston is incapable of staying out of trouble in Nevada casinos. He's been arrested by Gaming Control Board agents, not other law enforcement, just Gaming Control Board agents, approximately 34 times over the last 31 years. And these arrests have been based on the theft of casino gaming chips from patrons and from licensees, and also counterfeit casino gaming chip production. Thus, I request the Commission act today to place Mr. Hairston on Nevada's list of excluded persons. Thank you.
Mr. Hairston?
Yes, again, Commissioner, I'd like to ask the Commissioner to really reconsider the documents that I served you today about these unfiled documents, because like I say, if I was getting married and my wife came back to me with a divorce paper and it didn't have a file stamp on it, I would tell her, hey, we're still lawfully married. Like I say, the record shows that I was it says right here, in the event a candidate does not request a hearing, which I did, the board will file with the commission the bill of particulars. I never got the file bill of particulars. So I was subjected to a defective process of service by the board. And so with me being served an unfiled bill of particulars, the agency never acquired jurisdiction, and all proceedings are null and void.
I disagree with you. Please
Okay.
move to your next argument.
Okay,
The good news is that's the 6th time you've made it, so
okay,
I think you're covered as far as documentation
okay,
of your position.
okay. But, and again, like I say, the arrest by the Gaming Control Board, they was all unlawful pursuant to NRS 465-101, because those arrests were property crimes. And I did not bring up the issues because I didn't want to subject them to liability, which liability would occur on the Gaming Control Board agents by conducting those unlawful arrests without in violation of NRS 465. And so that's all I have to say.
Okay, thank you. You have a right to have a rebuttal comments. Do you have any?
I do not, Chair. Thank you.
Okay. Before we deliberate, I first want to ask my fellow commissioners if you've all had an opportunity to look at each one of the defendant's exhibits. Commissioner Keycover?
Yes.
Commissioner Solis Rainey?
Yes.
Commissioner Cohen?
Yes.
Commissioner Brown?
Yes, thank you.
Okay. And then also before we deliberate, I would just like to point out that any decision in this case has to be based upon the preponderance of evidence standard. And that is, just for the record and for Mr. Hairston, The preponderance of evidence standard is such evidence as when considered and compared with that opposed to it, it has more convincing force and produces in the minds of the members of the commission not a belief that what is sought to be proved, a belief, that it was what it sought to be proved is more likely true than not true. So basically, 51%, 49% preponderance of the evidence standard. So now is the opportunity to have discussion and
Thank you, Madam Chair. As it relates to Mr. Hairston's position relating to service, I believe that our counsel has advised us that all of the service issues were proper and lawful. As it relates to his assertion of any unlawful arrest under NRS 465-101, that particular chapter relates to officers of licensees, not gaming control board officers. Gaming control board officers are post-certified and duly authorized under statute to make arrests for criminal violations outside of NRS 465. And I do believe that the documents provided by Mr. Hairston that do relate specifically to the exhibits provided by the Attorney General's office do not undercut the original disposition at the district court. So I believe that based on my review of the preponderance of the evidence, the Attorney General's office has made a case that he is eligible for listing in the excluded persons list, and I would believe that it would be appropriate. Thank you.
Good job. Thank you. I just wanted to say also, Mr. Hairston, I appreciate your arguments. I've looked at everything you've submitted. I do believe that despite the evidence that you provided, that the evidence submitted by the by the Attorney General's office demonstrates that you are eligible and you meet the guidelines. So I just wanted to thank you for being here and also for giving us the evidence and let you know that I did review it closely and considered it.
Commissioner Cohen.
Thank you. Mr. Harrison, a review of the evidence as submitted by the Gaming Control Board in this matter shows that you've been convicted of multiple felonies, many of which may have been regarding non-gaming crimes, nevertheless occurring in a gaming establishment. You fall within the definition of a person eligible for the Black Book. These are serial mean happening time and time again over the course of many, many years, involving counterfeiting chips, stealing chips from, a roulette table. These cannot be in any way, shape, or form excused. I don't believe, let me rephrase that. The state certainly proved their case by preponderance of the evidence, and I will support, should a motion be made, for your inclusion in the Black Book today.
Commissioner Brown.
Thank you, Mr. Hairston, for coming here today to present your arguments. I understood them. I think that your key argument today, setting aside the jurisdictional issue, which has been overruled by the chair today, the key issue I'm focusing on is your history of conduct. And I understand your argument where you make a distinction between theft crimes and gaming crimes, but I don't agree with the distinction that you've drawn. I think it's an artificial distinction. So stealing chips from a patron in Nevada who is a protected person who is here to gamble, I think you view that as a theft crime, but I view it as a gaming crime that includes the act of theft. And the felony convictions, the 3 of them that we've been presented with, have not been overturned, have not been dismissed. The volume of the arrests in the last 30 years, total of 34 at least, that I am aware of, is troubling to me. And there's been no evidence that you've provided to me to show me that you did not commit the crimes of which you were convicted, and that the 34 arrests were improper for any reason, and to the extent that you didn't do the things that were alleged. And so we had the opportunity for you today to provide the evidence under oath and to provide documents, and I did not see any documents that demonstrated that you were not in fact convicted of the felonies. So unfortunately, the opportunity you had did not give me enough information to undo the recommendation. So that's my concern here today. So thank you for coming before us, but I don't have anything before me that you've presented that gives me sufficient evidence. So I believe that the AG's office has met their burden for preponderance of the evidence for 3 of the 7 factors. Thank you.
Mr. Hairston, related to your exhibits, I'm going to give you the option of having them mailed to you within a day or 2, or coming back at a time certain to pick up the copies. I'm not going to be able to get it done like this very second. So can you advise me before I get to my comments, just ministerially, where you want these to go? Are you going to come back and pick them up in another day, or?
So I just come back and pick them up.
Okay, so later this afternoon?
Yeah, maybe this afternoon.
Okay. So where will he go?
The front desk?
Yes, if you go to the front desk,
Okay.
they will have the copies.
Okay, so let's say we're not done. We have this goes on, and then we need time to do that. So
Picking up tomorrow.
okay, perfect. Thank you. Okay, sorry, I just want to make sure he gets his exhibits because he asked for them. Okay, as far as my comments, I would say, number 1, I've dealt with a lot of proper person litigants in my day, and I do really appreciate Mr. Hairston's courtesy and appropriate conduct in these proceedings. And so I give you credit for that, sir. However, it's clear to me that the board has met the burden. It's also clear to me that your interpretation of the records of appeals being, of convictions being dismissed is just wrong. And so that's part of it. And so I'm prepared to entertain a motion, and I don't know who would like to make one.
Chair, I am prepared to make the motion. In the matter of the exclusion of Leonard Morgan Hairston from licensed gaming establishments in the state of Nevada, I hereby move to place Mr. Hairston on the list of excluded persons based upon the criteria specified in NRS 463.151 sub 2 and NRS 463.151. Subsections 3A and D. The motion for exclusion specifically is being based on the following: there being a preponderance of the evidence, Mr. Hairston has been convicted of felonies under Nevada law, NRS 463.151, sub 3, sub A. Number 2, Mr. Hairston has been convicted of crimes of moral turpitude, NRS 463.151, sub 3, sub A. Mr. Hairston has been excluded from establishments which conduct gaming by the written orders of governmental agencies, including but not limited to the 8th Judicial District Court, NRS 463.151, sub 3, sub D. The Commission finds each of these reasons for exclusions independent of any other reason and is sufficient for the Commission to place Mr. Hairston on Nevada's list of excluded persons.
Is there any discussion on the motion? There being none, all in favor say aye.
Aye.
And there are none opposed. Mr. Hairston, we will get those exhibits to you. And the order will be signed You know, there'll be some, I'm sure, appeal or petitions for judicial review timelines you'll have to honor if you choose to have this reviewed. So I'm going to sign the order. Can he, can he look at it? So obviously you're going to get a copy of this. Do you serve him or?
I think the executive secretary.
Okay.
Actually, I need to sign it real quick too.
Okay, sir, good luck.
Thank you.
Your items will be there for pickup tomorrow, okay? Thank you.